Rajshekhar, Professor and Head of Ahmed Business School, Ahmed University, Chennai. We are going to have a discussion on the subject called Business Law. In this Business Law, there are totally 5 units. The first and foremost important unit we are going to discuss, Unit 1, Indian Contract Act 1872. Commonly, in the day-to-day, those who want to have any transactions with regard with any related documentations, whereas contract which is very much important between the parties. So here the Indian Contract Act 1872, which has been enacted for the purpose of having the contract between the parties in order to avoid the disputes in future. And there are various topics for the today's session. We are going to discuss on Indian Contract Act 1872, the definition of contract, essential elements of valid contract, offer, acceptance, consideration and capacity of parties, formation of contract, performance of contract, remedies for breach of contract and quasi-contract. The definition of contract according to section 2H of Indian Contract Act 1872, an agreement enforceable by law is a contract. So what is the meaning of agreement? It's an offer plus acceptance equal to agreement. One person who giving the offer is called as offeror, other person who accepting the offer is called as acceptance. So here, whereas two parties, offeror and acceptor, entered an agreement, it should be enforceable by law. Then only it is called as contract. Whereas if any agreement is enforceable by law, it is a contract. In this contract, as he told, there are two important parties. One is offeror, the person who is making the offer. Another person is acceptor, the person to whom the offer is made. Now there are various classification of contract. Under classification, there are major 3 important classifications. One is validity, another one is formation, another one is performance. So now the first one is validity. Under validity, valid contract, void contract, voidable contract, illegal contract, unenforceable contract. So all these contracts which comes under the head called validity. The second one is formation. So under the formation, express contract, implied contract, quasi-contract and tacit contract. The third one is performance. Under performance, executed contract, executory contract, unilateral contract and bilateral contract. So the previous one what we have discussed, which I given the explanation on definition of contract, offer plus acceptance equal to agreement and it should be enforceable by law. Same way under the same contract there are various classifications. For that there are 3 heads. One is validity and formation and performance, which we are going to discuss in detail with the various examples. Now according to validity, as I told, according to validity, first one is valid contract. Valid contract means fulfills the essentials of a valid contract or agreement. Agreement means offer plus acceptance equal to agreement. Contract means offer plus acceptance equal to agreement equal to contract, but it should be enforceable by law. So for example, X offers to sell his car for rupees 5 lakh to Y. Y also agrees to buy, then it is called a valid contract. So one person who making the offer is called as offeror, other person who accepting the offer is called as acceptor, but both the parties are fulfilled the essentials of a valid agreement or contract, then it is called as valid contract. Second one is voidable contract. The voidable contract is an agreement which is enforceable by law. It is the option of one or more parties. It is the option of one or more parties. But when this voidable contract may come into force, there is another important concept called free consent is required between the parties, those who are going to enter the contract. But here, whenever free consent is missing, whenever free consent is missing, immediately it is called as voidable contract. So voidable contract may come into force when the free consent is missing. And the another one is whenever agreements are caused by either coercion is called as threatening, either coercion or undue influence, gaining the advantage over the other party, undue influence. Third one is misrepresentation, without any intention is called as misrepresentation. Fraud with an intention are voidable. Say for example, X wants to sell his land to B for rupees 10 lakh under coercion, under threatening, then it is called as voidable contract at the option of that specific party. So under validity, now we have discussed two things. One is point number one, valid contract, and the second one is voidable contract. Third one is same according to validity, void contract. Previously what we have discussed is called as voidable contract, which is totally different from the void contract. Agreement not enforceable by law. Not enforceable by law. As I told already, offer plus acceptance equal to agreement, it should be enforceable by law. But here void contract, an agreement not enforceable by law. Say for example, even this void contract, there is an example. X promised to give his house to Y, who wants to use it for smuggling purpose. Smuggling is an illegal. So even later, if there is any dispute between the parties, they cannot go to the court. There is this, the sentence of void contract. It cannot be enforceable by law. Hence it is called as void contract. And the next one is illegal contract. Illegal contract means the object is totally illegal or against the law. It is called as illegal contract. Say for example, a contract which is required between the parties to commit a murder. So here murder which is totally illegal or against the law. The object is called as murder. Murder is illegal or it is totally against the law. Hence it is called as what? Illegal contract. Fifth one is same under according to validity, unenforceable contract. Unenforceable contract is one which cannot be enforced in a court of law due to some technical defect. Say for example, while entered with an agreement, as I told, an offer, acceptance equal to agreement, but a contract which is required. What is the meaning of technical defect in unenforceable contract? Means absence of writing or want of stamp which is required in a promissory note. These are all called as technical defect. For these reasons, it cannot be enforceable. Hence, it is called as unenforceable contract. So, according to validity, void contract, valid contract, voidable contract, illegal contract, unenforceable contract we have discussed. Then the next one is according to formation. According to formation, express contract is there. The meaning of express called as spoken or written at the time of formation of contract. Spoken words or written at the time of formation of contract is called as express contract. Second one is important contract. It is called as implied contract. See, implied contract means is one which shows the evidence of the agreement, okay, by act or conduct of the parties, by act or conduct of the parties, but not by words or written. As I told in the express contract means spoken words are written, but here not by spoken words are written, only by the act or conduct of the parties. Now you may have doubt. So what is the meaning of act or conduct of the parties? As per this implied contract, there is an example. Say for X gets into a public bus, immediately there is an implied contract that he will pay the bus fare. So what will happen? The conductor will come to him and there is no other way. Once the person wants to step inside, he need to pay the bus fare. It is called as what? Implied contract. Then the next one is quasi-contract. Quasi-contract is not, in truth, quasi-contract is not a contract at all. Okay, but at the same time, a person shall not enrich himself unjustly at the expense of the other party. This is the actual meaning of quasi-contract. So a person shall not be allowed to enrich himself at the expense of other party. So why this quasi-contract is important? It's just a principle of equity and justice. Say for example, A delivers goods to B, mistaking to be C, and B uses the goods. B uses the goods. Actually, you need to deliver the goods to C, but practically mistakenly B also use the goods. Now B is under an obligation to pay compensation to A for the value of the goods. So here the law totally imposed one duty on whom means duty on B. So there is no contract between A and B. As I told, a person shall not allowed enrich himself at the expense of the other party, or the principle of equity and justice. But still, the B want to use the goods mistakenly, but he is under obligation to pay the compensation to A. It is called as what? Quasi-contract. Next one is tacit contract. Tacit contract means inferred from the conduct of the parties. Inferred from the conduct of the parties. Say for example, during the time of auction, the sale by fall of hammer, they will say. So that first time, second time, while they are using the hammer itself, the other parties, those who are sitting there, and comes to conclude that the auction gets to over or completed. It's called as what? Tacit contract, inferred from the conduct of parties. So according to formation, express contract, implied contract, act or conduct of the parties called as implied, spoken or oral words is called as express. Then quasi-contract means shall not enrich himself at the expense of other party, just a principle of equity and justice. Tacit contract, inferred from the conduct of the parties. So there are four major types which we have discussed under according to formation. According to performance, executed contract. So what is the meaning of executed contract? Both the parties have performed their obligations, whereas offeror, acceptor have performed their obligation, called as executed contract. Say P sold his car to K for rupees 5 lakh. And K also paid the price. Here one party sold the car, another party paid the price. Both the parties, they perform their obligation as per the contract is called as executed contract. Both the parties have performed, hence it is called as executed contract. Another one is executory contract. Executory contract means yet to performed either by one or both the parties. Either by one or both the parties. Say for example, P agreed to sell his car to K, as we have discussed with the previous point. Same way here also, P agrees to sell his car to K, and K in consideration promises to pay P rupees 5 lakh. So one party is required to pay, another party is required to sell, but both the parties are under obligation, still not yet completed or under an obligation. It is called as executory contract. Executory contract. Unilateral contract means at the time of contract itself, one party perform and the other party will not yet perform the obligation. One party perform, another party not yet perform the obligation is called as unilateral contract. So point number one, executed, both the parties perform. Executory, yet to perform either by one or both the parties. Unilateral, at the time of contract itself, one party perform the contract. Bilateral contract is both the parties have not performed their obligation at the time of contract. So unilateral, bilateral, which clearly explains that at the time of contract, whereas both the party whether they have performed, or one party whether performed, another party not yet performed. Unilateral is called as one-sided contract also. So these are the differences which are required to understand when we are writing the concept of according to performance. Executed, both the parties. Executory, yet to perform either by one or both of the parties. Unilateral, at the time of formation of contract, one party perform the contract. Bilateral, both the parties have not yet performed the obligation at the time of contract. So, what are the essential elements of valid contract? Agreement, intention to create a legal relationship, writing and registration, free consent is required, lawful consideration, certainty of meaning, not expressly declared void, it is called as void agreements, performance possibility, legal object and competency. So there are various points which are required under essential elements of valid contract. So point number 1, offer and acceptance. There are two parties are equal to an agreement. As I told, one is offer, another one is acceptance. It is called as offer and acceptance. So point number 1, offer and acceptance. The parties where they are going to enter offer and acceptance, offeror and acceptor. What type of relationship which is very much important between them? Legal relationship. The point number 2, legal relationship. Say for example, section legal relationship, intention which is required to create legal relationship between the parties. There is a case law called Balfour versus Balfour. It's a famous case law. The reason is husband and wife. Later the husband promised to wife to give some, he promised to wife is going to pay some amount of money every month, but afterwards both of them are separated. Whatever the husband promised, he is totally failed to provide that amount of compensation, but the wife went to court and filed the suit. So whatever the conversation which was happened between them is just a social nature of conversation between them. So any domestic or social, since there is no legal relationship, at any cost wife doesn't have right to get any amount through the court from the husband. It is called as legal relationship. Third one is lawful consideration. Section 2D. Lawful consideration, something in return. It is called as quid pro quo, either cash or kind. See, an agreement without consideration is void. An agreement without consideration is void. There are three important points. One is an act. Another one is doing of something. Doing of something means promisor receiving some benefit from selling of the goods. What benefit? The price. Okay. Point number 3, subsistence or forbearance. First one is act between the parties. Second one is doing of something. Third one is subsistence or forbearance. See here, the third one is it is a negative act. Negative act. Say for example, A promises to other person, okay, not to file a case, provided he must get rupees 500. Okay, it's just a negative term. So hence it is called as subsistence or forbearance. And the next one is a written promise. A promised B to subscribe rupees 500 for the rebuilding of the mosque. Later, he failed to pay. Now your contract was not enforceable. Why the contract is not enforceable? Means there is no consideration. What is the meaning of consideration? Quid pro quo. What is the another name? As I told, I have told something in return. Something in return. It is called as what? Either cash or kind. So consideration. There are three important points. One is act, doing of something. Second one is subsistence or forbearance. Point number 2, it's a negative act. I have given the example, not to file, okay, provided he must get rupees 500. Third one is a written promise, but there is no consideration. Consideration is absent, means then there is no contract. So there are three essential elements so far we have discussed. One is offer and acceptance. Second one is legal relationship. Third one is lawful consideration. Fourth one is lawful object. Section 23, the purpose of an agreement must be lawful. So any party, those who are going to have a contract, okay, the agreement must be lawful agreement. It should not be opposed to immoral, illegal or opposed to public policy. Okay, say for example, A promised to get and employment in public service by getting some bribe, totally against. As I told already, A and B entered with an agreement in order to commit a murder. Again, it's an illegal. So likewise, any party, those who are going to have a contract, that contract must not be immoral or illegal or opposed to public policy. Then only it is called as lawful object. Next one is consent of parties. See, free consent which is required between the parties. Either offer or an acceptor, the free consent is required. The section 13 and 14 which gives the clear explanation on free consent. So there is a case called Ranganayakama vs. Abar Chetty. This case also deals with at the time of cremation, whereas some group of people are opposing her not to do any cremation, okay, in order to just transferring the property to the other party. So here coercion, it is called as threatening the person not to do the fact immediately unless and otherwise, whereas the properties need to be transferred. Okay, so coercion is called as threatening. Free consent which is required whenever the parties, those who are going to enter the contract. Okay, if there is no free consent, as I told already, free consent is missing, no contract at all. The second one is an agreement caused by coercion, undue influence, fraud, intention will be present. Fraud is called as intention. Misrepresentation means cheating but without knowledge. Cheating without knowledge. But here the contract is voidable. Even in the voidable contract, I have told agreement caused by coercion, threatening. Second one, undue influence, gaining the advantage over the other party from the other party. It's a relationship between police and accused. It's a relationship between lawyer and the client. Okay, so likewise, gaining the advantage from the other party is called as undue influence. And the third one is fraud, intention. Misrepresentation means cheating without the knowledge, the contract. All these contract is called voidable. Capacity of parties, section 11 clearly explains that capacity of parties. So those who are going to enter in the contract, the point number 1, age of majority, they should attain the age of majority. Point number 2, sound mind is required. Point number 3, they should not disqualified by any laws. So these three are called as capacity of parties. So parties are not capable, the contract is void. So parties, those who are not capable, either unsound mind or disqualified by law or not yet attained the age of majority, the contract is totally void. Then there is a case called Mugri Bibi vs. Dharmadas Ghosh. It is a famous case law for the capacity of parties. And another example is that, see, X is a person, unsound mind, that he want to agree to sell his house to other party for rupees 5 lakh. But do you think that whether this contract is valid? It is not a valid contract, because the party who is showing his willingness to selling the property to other party is having what type of mind? Unsound mind. So parties, those who are having unsound mind, the parties, those who are having minority, the parties, those who are disqualified by law, totally the contract is void. It's called as capacity of parties, section 11. Next one is certainty of terms, section 29 of Indian Contract Act 1872. Okay, agreement must be precise and must not be vague. Say for example, A informed to sell his car to C, but A is having 4 cars, but nothing stated about which car is going to sell. The other party may had thought that he is going to sell a second one, but the party who had an idea to sell his car, okay, in his mind he is having a thought to sell first one, not the second one. So both the parties are what? Certainty of terms are totally missing. So whenever the parties are entered a contract, the certainty of terms, it is very much important between the parties, then only it is called as valid contract. So possibility of performance, next one. As per section 56, an agreement must be capable of being performed. An agreement to do an impossible act, if there is an impossible act which cannot be enforced, then it is called as possibility of performance. Say for example, A agrees with B to put life into B's dead wife. The agreement is void because it is impossible performance. A agrees with B to put life into B's dead wife. Just is giving the statement that okay, it is totally impossible to him, whereas the person who died, he cannot able to bring the person as a life. So it is totally impossible. It is called as what? Even here contract may not be accepted. Contract is void. So only the contract can be happen for the possibility of performance, not for the impossibility of performance. Next one is agreement not declared, express declared as void. Say an agreement in restraint of marriage. There are legal formalities. Last one is legal formalities. This agreement not expressly declared as void is called as void agreements. Void agreements. There are various reasons, but we are going to discuss this void agreement alone separately. It is very much important to understood. And at the same time, the last one is legal formalities. Any document, writing, registration, attestation is required. So agreement does not comply with all these legal formalities. What? Writing, registration and attestation, even stamping also which is required. Otherwise the law cannot enforce it. So whatever we have discussed so far, the various essential elements of valid contract. The next one is void agreements. See section 2G of Indian Contract Act 1872. A void agreement is one which is not enforceable by law. Very important point. Offer plus acceptance equal to agreement equal to contract should be enforceable by law. But here not enforceable by law. What are void agreements? And at the same time, this void agreement is void ab initio from the beginning itself. Right from the beginning itself, it is called as void agreement. Say for example, if the agreements by incompetent parties, the parties are not yet competent, incompetent as per section 11. Okay, the agreement is void. Agreement made under mutual mistake of fact, section 20. Mutual mistake, both the parties where they are involved in the mutual mistake of fact, section 20. Agreement is void. Agreement in the consideration or object, as I told, object is lawful but the object is unlawful. Agreement is void as per section 23 Indian Contract Act 1872. And section 24. Section 23, consideration or object is unlawful. Section 24, consideration or object is unlawful even in part, also void. Agreements made without consideration, section 25. Previously when I have explained the concept for consideration, the consideration is very much important. Without consideration there is no contract. So any agreement made without consideration as per section 25, it is void. Agreement in restraint of marriage, section 26 of Indian Contract Act 1872, it is void agreement. Agreement in restraint of trade, section 27. Agreement in restraint of legal proceedings, section 28. Agreement in which the meaning is uncertain, as I told, certainty of terms are very much important, but the certainties are terms is totally uncertain. Both the parties not able to understand as per section 29. Void agreement. Agreement by way of wager, section 30. Void agreement. Agreements contingent on impossible events. Only for the possibility of performance you can enter an agreement, but impossible events we cannot able to enter with that agreement. Hence it is void. Section 36. Agreements to do impossible act, section 56 also void agreement. So what is meant by void agreement? Which cannot be enforceable by law from the beginning, void ab initio, from the beginning itself, it is called as what? Void agreement. Then the remedies for breach of contract. There are 5 important remedies. One is rescission, second one is suit for damages, third one is suit for specific performance, fourth one is quantum merit, next one is suit for injunction. So first one is rescission, remedies for breach of contract. First one is rescission. It is called as setting aside the contract. Say for example, A promised to supply B 20 bags of rice. B also agrees to pay after delivery of rice. But A refused to delivery. One party refused to delivery. Let he can resign the contract. Is discharged from liability to pay the price. Hence it is called as what? Rescission of contract. Rescission means setting aside the contract. Second one is damages. Damages means monetary compensation which is required to allow to the injured party by the court for loss or injury. So two things, either for loss or injuries suffered as a result of what? Breach of contract, called as damages. But there are various types of damages. Say compensatory damages, general damages, and the compensatory damages only general damages. General damages used to arise naturally from the breach of contract. Special damages, for the special circumstances foreseeable, this type of damage may come. Vindictive or exemplary damages, disappointment or mental agony, these type of damages may arise. Nominal damages. Nominal damages means right to injured party to claim damages. Injured parties having right to claim damages is called as nominal damages. Duty to mitigate damages suffered at any cost, as much as possible they have to see that not to affect very huge amount of loss. They have to see that try to reduce the loss. And liquidated damages, the sum of money stipulated in the contract, whatever the sum which they have been included in the contract to be paid in case the contract is broken by the parties, called as liquidated damages. So these are the various types of damages. Next one is quantum merit. So what is meant by quantum merit? As much as earned, it is called as quantum merit. Payment in proportion to the work done. Say for example, C engaged B to write a book. Okay, for that they agreed to pay the price in form of installment for the weekly magazine. After a few issues, the magazine closed down. Now, a party may have right to recover the amount for the magazine what they have written. Okay, so recover on quantum merit for the work done under the contract. As much as, say for example, if he has written 5 issues for the magazine, later the magazine is just closed down. So what he has written for that 5 magazine, he is having eligible to get what? Some amount of money from the respective publisher. It is called as quantum merit, as much as here. Next one is specific performance. See, actual carrying out of the promise by the party in which exactly according to the terms of the contract, but the specific performance, say for example, here damages not an adequate remedy. Under specific performance, damages are not adequate remedy, but at the same time, what is the meaning of specific performance? They have to follow as per the according to the terms of the contract. Say for example, X entered to a sale and purchase agreement with Y, purchase a piece of land. Y later terminated the sale and purchase agreement. Now the X party, when I entered into the sale and purchase agreement, may have right to file a case against Y for specific performance, compelling Y to sell land to him, called as specific. As according to the terms of contract, the party, those who break at any cost, the specific party may ask him to complete the contract as per the terms, is called as what? Specific performance of the contract. Now point number 1, we have discussed the rescission. Point number 2, the damages. And point number 3, quantum merit. Point number 4, specific performance. Point number 5, injunction. Injunction means order of court restraining a person from doing a particular act is called as injunction. See, injunction, grant of injunction is normally a discretionary. The court may have right to discretionary powers in order to what? Grant the injunction. Okay, injunction is just stopping a person not to involve to do the fact. So court will grant the injunction. Promiser undertakes not to do something. I am the party who no promise, but later if I am not going to do something, the other party can go to the court and ask the court to grant what? Injunction. But at that time the court, after seeing the circumstances, may grant or not to grant. The court is having the decision, can take the decision, or court is having the power not to carry on a certain trade. So it's one of the case law, Nordenfeld versus Maxim, Nordenfeld Company Limited. But as per this case, already entered in the contract by saying that not to carry on a certain trade. If later the same party one is going to do any other trade, same trade without following the contract, means now he may have right to what? Get an injunction order in stopping the person not to further continue in doing the business. Another one is, it is a negative in substances thought not in form. Another important point under the injunction. Negative in substance though not in form. So there is a case, Lumley versus Wagner. W agreed to sing in L theatre during that particular period. Okay, but later this party, what he is doing, refused to sing in L theatre. Already contract is over, agreed, but later refused. Now what let the L can do? Okay, L immediately he can go to the court and get an injunction, ask the person to stop not to perform in any other theatre. Let you need to complete that contract as per the terms. It is called as what? Negative in substance though not in form. So there are various types of injunction, permanent injunction and temporary injunction, but as per the remedies for breach of contract, break the contract, what are all the various remedies? Means there are 5 major remedies. In short form, we have discussed rescission, damages, quantum merit, specific performance and injunction. Performance of contract. See, the performance of contract means both the promisor and promisee have fulfilled their respective obligations which the contract placed upon them. Both the parties, promisor and promisee. Say for example, if A visits a stationery shop to buy a calculator, the shopkeeper delivers the calculator and A pays the price. So both promisor and promisee, they have performed. Hence it is called a performance of contract. Or else parties to a contract must either perform or offer to perform their respective promises. Again, I am repeating, parties to a contract must either perform, either they have to perform or offer to perform their respective promises. Say for example, A promised to deliver goods to B on a certain day on payment of ₹5,000. But A expires before the contracted date. Now what will happen? A's representatives are bound to deliver the goods to B and B is bound to pay ₹5,000 to A's representatives. Okay, so this is an example which clearly explains that either the parties need to perform or offer to perform their respective promises. It is called as performance of contract. So far, definition of contract, essential elements of contract, then the classification of contract, remedies for breach of contract, performance of contract, which we have discussed for the subject called business law and Unit 1 Indian Contract Act 1872. We will have the discussion Unit 2 in the next session. Thank you all.